Welcome to our channel. This is Attorney Louis Liu. Today I will be discussing with you how to properly draft a term sheet or a letter of intent or a memorandum of understanding or documents of similar nature. My overall advice is that it's still the best for you not to do it by yourself. It's the best for you to engage properly trained business transactional lawyer to draft it for you. There are two reasons for that. First, a poorly drafted term sheet may unintentionally create legally binding obligations when none of such obligations were intended. Second, once it's signed, moreover, it's difficult for you to change the substantive terms without good reasons, although it is not meant to be legally binding. You can imagine if you actually move forward with the transaction, unless you discover some kind of material adverse issue of your contractual counterparty, being it acquisition target, meaning a business company that you want to buy, or being a target of your investment, or just your contractual counterparty that you intend to do some sort of business with, right? Or if there's any kind of external change of environment that justified your proposed change to the terms and conditions of the actual economic transaction. The first tip is that you need to bifurcate the binding and non-binding provisions of the term sheet. You should try to avoid any ambiguity by clearly stating the bifurcation, by clearly pointing out what provisions of this term sheet are binding, what provisions of this term sheet are not binding. And you should further state the conditional nature of the term sheet with respect to the non-binding provisions. You should say, we are going forward with this deal only upon satisfactory due diligence investigation by us. And the whole deal as proposed is subject to corporate authorization, meaning if it's for a mergers acquisition or similar transactions, you need a shareholders approval. For other kind of material transactions, you at least would need the board approval. And in the case of private equity fund or a venture capital fund, making investment in a venture company, the approval of the investment committee of the fund. And you need go further to say that, those terms are just for us to forms the basis for our discussion and the negotiation. The specific actual terms of conditions of the transaction, if we go forward with a transaction, will be separately, fully documented in a set of transactional documents that are going to have a binding effect. And as I said, the substantive economic terms shall not be binding, and you should almost repeatedly see that in the term sheet, in the letter of intent, in the memorandum of understanding. The third part is the binding provisions. The following usually are binding provisions. First, exclusivity, especially in the context of merger acquisition transaction. You need to state for the next 30, 60, 90 days, you, the target company, will be only discussing with us for such a potential strategic transaction. And relate to that and derive from that, you need to conduct your business as usual. You should not be engaged in any kind of extraordinary transactions. And but be careful, there's this fiduciary duty of the target company's board, meaning they could not totally exclusively being bound by you with this exclusivity provision. They do have some kind of fiduciary duty to at least not to reject any kind of better offers for you, because that's the board's duty to the shareholders of the company. So you could not literally count on the binding and exclusivity provision. And then the second is the confidentiality obligation. Sometimes people will have a confidentiality agreement signed already before they sign the term sheet. And that's when they start to do some kind of preliminary due diligence investigation of each other. That's fine. Sometimes you make reference to that document, which is binding. And then you need to stipulate how fees and costs are going to be allocated. Usually in this kind of a term sheet, each party to the term sheet share like bears their own burden of costs and expenses. And then you need to have governing law and other general provisions. Those provisions need to be binding. So this is today's presentation. Thank you for your time. If you are interested, you are welcome to subscribe to our channel. Thank you.